keep it reasonable is all I ask, just out of respect for everybody else who's agreed to certain times. I'm not saying you're going to go over, but I'm just saying that to everybody. That's generally my approach. So I'm not I'm not going to hold you to the times, but you've agreed to them, and out of fairness to your friends, we should try to stick to those. So that's all I wanted to say. So whether we finish the AFN submissions today or not, we'll cross that bridge when we come to it. So with that, I'll turn it over to Ms. Clark for the continuation of your submissions.
Thank you, Your Honor, and thank you for those comments around the timing. I'm just going to run back to my car and get an extra 2 hours worth of submissions that I forgot there. Just kidding. Okay, so you're right. We are exactly in the middle of the 6 points that the Caring Society has raised in response to Canada's judicial review. And so I plan to wrap up my submissions this morning with an examination of those 3 final points. So just to review those for Your Honor this morning, the first thing I plan to do is to review the definitions decision. This is the decision of the tribunal that provides the parameters around what it meant from the compensation entitlement order with respect to service gap, essential service, and unreasonable delay. Again, taking you through the decision, we say will demonstrate both the reasoning process undertaken by the tribunal and the outcome, which are both reasonable. Second, I'm going to address some of Canada's direct attacks on the reasons and approach taken by the tribunal, particularly based on some of Canada's comments yesterday. I plan to address the sufficiency of the evidence argument, the tort law argument, and here I'm going to particularly address Canada's concerns around causation and proportionality, both concepts that come from tort law and are really not applicable in this case. And then I'm going to address some of the concerns raised by Canada around the tribunal's procedure. So that's with respect to the ongoing nature of the discrimination, as well as compensation for Jordan's principal children. Finally, I'm going to turn to the tribunal's findings regarding the willful and reckless nature of Canada's discrimination in this case. And I think it goes without saying to just point out that the willful and reckless grounding of the tribunal's reasons are hooked in mainly to the 2016 merits decision. And so for Canada to come now and say that it was not willful or reckless in its discrimination, we say comes dangerously close to trying to overturn or repurpose or reframe many of the findings from the 2016 merits decision. So that's what I hope to accomplish this morning. Of course, as yesterday, if there are questions, please just interrupt me. I'm happy to take those at any time. So I'd like to take you now to the definitions decision, and I'm going to use, again, as I did yesterday, Canada's compendium. So the decisions definition is found in volume 2 of the Attorney General's compendium, and it's at tab 2. So I just want to put this decision in context for the court. This order was made with respect to the definitions following some of the work that the parties had done together to outline the compensation payment process. As you will recall, Canada fought in this court to stay the process of consultation while the application for judicial review was adjudicated. But that motion was ultimately dismissed by the court, and therefore Canada was forced to engage in the process with the parties as ordered by the tribunal. So what happened next, we say, demonstrates the overall reasonableness of the decision. And that is the parties, the Caring Society, the Assembly of First Nations, and Canada, were able to create a compensation framework. And while it's we say a very important piece of work that has been done by the parties in this case, it actually shows to illuminate and amplify the reasonableness of the tribunal's orders, because we were able to craft a process, and that compensation framework, just for your bench brief, Your Honor, is at tab 50 of our compendium. That framework is able to really take into consideration the unique needs of First Nations children, the unique needs of the victims here in this case, and actually create a process that's going to be efficient and sensitive and provide really both a fair approach for the government as well as the parties to ensure that the victims in this case are protected. And so while we were working on that framework, there would be from time to time, as Mr. Frater mentioned yesterday, we would return to the tribunal if there was something that we could not agree upon. And that is what the the definitions decision was about. So I do urge the court to review the compensation framework in its totality, because I think it answers a lot of questions about the nature and the scope of the compensation that has been ordered here, really further demonstrating the reasonableness of the decision. So as Mr. Frater mentioned yesterday, the definitions decision comes based on the fact that we could not agree on certain terms that were found in the compensation entitlement order. And those were service gap, essential service, and unreasonable delay. Canada now takes issue with these definitions because the tribunal did not order that these definitions comply with the actual definition of Jordan's principle. And that's not the case. There has been no evolving parameters or expansion of Jordan's principle over the years. As I said yesterday, Jordan's principle, the definition of Jordan's principle that we find in the 2017 orders was a direct result of Canada's failure to comply with the guidance and the direction of the merits decision. So the definition that you see in the 2017 orders in particular was always thus. But what was required by the tribunal was to provide specific parameters and refinements, because Canada could not or would not actually implement the true meaning of Jordan's principle as it was conceptualized both in the House of Commons motion from 2007 all the way until 2016. Now, it's important to review the definitions decision in its totality because it demonstrates again the reasonable, logical, and internally coherent nature of what the tribunal did. So I want to, while part of this decision is not under review by Canada, I actually think reviewing the entirety of it shows, again, how reasonable and consistent the tribunal has been. So if we look at paragraph 12, we see again the tribunal's consideration of the victim's rights in this case. And here, the tribunal had reviewed the draft framework and had some comments about the direction that we were going as the parties. And at the bottom, the tribunal says, the opt-out provision in the draft compensation framework addresses the right of any beneficiary to renounce compensation under this process and pursue other recourses should they opt to do so. The opt-out provision protects the rights of people who disagree with this process and who prefer to follow other paths. So I'm going to come back to this idea later today, but this really demonstrates the tribunal's acknowledgement that there may be other avenues that victims wish to pursue, and there's nothing in the compensation entitlement decision or in the compensation framework that bars or restricts victims from opting out. Now, the first half of the decision is important to review to understand the overall reasonableness of it. Canada would have you think that the tribunal had no limits on what it ordered with respect to compensation, but that's not the case. Yesterday, I was remiss to point out that in the compensation decision, the tribunal did actually not order compensation for every child that we, the Caring Society, actually asked for. We had asked for compensation be ordered for every removed child. The tribunal did not agree with our approach on that issue and actually restricted the category of every child removed to every child removed from their home, community, and family. So this is a smaller number of children that we were asking for be compensated. Now, in the definitions decision, the Chiefs of Ontario and Anishinaabe-Aski Nation, and here this decision starts at paragraph 14, had requested that the tribunal broaden the category of beneficiaries to include those off reserve, but the tribunal would not do that. And so at paragraphs 22 and 23, the tribunal explains its reasoning, that it actually looked very hard at the evidence and the scope of the complaint, and as well as what was discussed as we've moved through this whole process, to say that really we cannot add off reserve into the category of those who should be compensated. There was also an additional request for additional caregivers, and this too was denied by the tribunal. At paragraphs 41 through 46, and ultimately at paragraph 50, the tribunal refuses to broaden the category of caregivers. So this demonstrates that the tribunal has a very acute awareness of its limits, that it can only order remedies that flow from the complaint, the statement of the particulars, and the specific facts of the case. And because the evidence did not support these two additional categories, the tribunal refused to give those amendments. I would also point, Your Honor, to paragraphs 58 through 60, which addresses a concern that was raised at the time by Canada regarding procedural fairness. Canada had raised a concern that Chiefs of Ontario and Anishinaabe Nation had filed submissions after the deadline. And the tribunal addresses this concern here with logic grounded in the legal principles that guide the tribunal's approach, which is one of flexibility and ensuring that ultimately the rights of those who are a party to the litigation are protected. Really, the tribunal finds that there's been no prejudice here to Canada, and so dismisses its concern on that respect, with respect to that. So now really getting to the meat of the decision here, the service gap discussion starts at page 20. And again, in very much a similar manner that the tribunal did with the compensation entitlement order, the tribunal spends a lot of time considering and properly weighing the arguments raised by Canada. And those are found at paragraphs 65 through 71. The tribunal closely examines and considers Canada's argument. It wanted there to be a request for the service in order for that service gap definition to apply, a dispute, the application of a normative standard, and ultimately that the service, product, or support be recommended by a professional. Now, with respect to the request provision, the tribunal reviewed the record and determined, based on its previous rulings, that you could not make a request. And this is one of the things that we talked about yesterday, which is why it was more than reasonable for the tribunal to find that a request should not form one of the conditions for compensation under Jordan's principle. At paragraph 90, the tribunal clearly states, taken together, the record before the tribunal shows that Canada crafted a system that blocked service and product requests from coming forward, and now seeks to benefit from that system to reduce the scope of victims entitled to compensation for their pain and suffering resulted from this willful and reckless discrimination. I mean, that alone demonstrates the internally coherent nature of the tribunal's reasons. Really what the tribunal is saying, and probably more eloquently than I could ever do myself, but really what was happening here was Canada was attempting to benefit from its own discrimination. You couldn't make a request. Families couldn't make a request directly to the department. And Canada's witness, Ms. Bagley, confirmed that in cross-examination. But it was coming back with this notion of a request to try to limit the scope of the compensation. And the tribunal on that point quite reasonably says, you can't benefit from your discrimination in order to save money. So carrying on with the definition of service request, I'd like to take you to paragraphs 106 and 108. So here, the tribunal, again, looking at its past findings and approach to remedying discrimination, makes it very clear to say that the tribunal's focus on the ability of First Nations children to access services and products that were required is what the focus of the category is. A service gap should be defined with a reference to a child's confirmed needs during the period of Canada's discrimination, and such needs should be assessed based on the principles of a child's best interest, substantive equality, overcoming historic disadvantages, and consideration of distinct circumstances. This is the grounding of Jordan's principle. This is the scope and the entire nature of the definition of Jordan's principle, which Canada did not seek to judicially review. So once again, this demonstrates a clear connection to the definition of Jordan's principle that has been unchallenged by the government of Canada. Now, one thing that was pointed out by Mr. Frater yesterday, and we agree that at paragraph 117, The tribunal did agree with Canada on the need that the service, product, or support be recommended by a professional. This is an important consideration in understanding the reasonableness of what the tribunal has done here. The tribunal says that it agrees in merit in Canada's argument that a service should have been recommended by a professional with the relevant expertise to determine that the service is essential to meet the child's needs. So it's important to keep in mind that when Canada says anybody, who needed any kind of service, product, or support is going to get compensation, that is not true. The tribunal reasonably said it's got to be actually recommended by a professional. And that in and of itself is a mechanism, if you will, a practical mechanism for actually ensuring that there was real discrimination done to the child who's seeking compensation. So if you had a professional recommend autism services, for example, obviously, if that child does not get those services, there will be harm. And that is a reasonable conclusion within the context of any child development, child well-being, and best interests of the child analysis performed in the context of this case. So there is a limit and there is a boundary, and the tribunal recognizes the need for that, just further demonstrating its reasonableness. So I'm going to move now to and I would just say on paragraph 120, I know that I am a bit crunched for time, so we're not going to read it to you. But again, the tribunal just comes back to its definition of Jordan's principle. To say that it would be with respect to the normative standard is not in keeping with the definition of Jordan's principle. And actually, I would say that if the tribunal had actually deviated from its own definition of Jordan's principle found in the 2017 orders, that in and of itself would have been internally inconsistent and totally unreasonable. So what it's done here is tracked its own orders, and on that basis alone, we say demonstrates the tribunal's reasonableness on that point. Now, turning to essential service, again, the tribunal places limits. At paragraph 124, the tribunal says the following. The tribunal's reference to real harm is a significant qualifier, one that accords with a common sense understanding of what is truly essential. Not all supports, products, and services are equally necessary, and the failure to provide them or the failure to provide them in a timely way should not be compensable. And so what the parties ultimately did, and this is why I urge you to look at the compensation framework itself, is take this guidance from the tribunal and actually construct a definition of essential service that doesn't sort of leave the door open for any service. There are these limits that the tribunal has placed on the definition of essential service. And so there is a way to ensure that those who seek compensation and are ultimately benefited by compensation actually have a limit to who can have access to it. It has to actually be essential. Now, one of the things, again, that Canada wanted was there to be a request. The panel says, no, the evidence doesn't support that, and that's at paragraph 146. And again, at 147, the tribunal talks about the necessity for substantive equality. And as I have said, this tracks the previous orders of Jordan's principle from 2017 that have not been judicially reviewed. Again, the tribunal clearly takes into consideration Canada's concerns and arguments that it raises and addresses them directly in paragraphs 148 and 151. Now, with respect to unreasonable delay, Canada's concern here, as articulated yesterday by my friend Mr. Frater, seems to be around the normative standard. His example was, why should a First Nations child get something faster than any other Canadian? And if they don't, that they can somehow be entitled to compensation. But we have to keep in mind what the tribunal is doing here. The definition of Jordan's principle is not about normative standards. And the tribunal has said that countless times, and Canada knows that, and it did not seek to review those. But the tribunal can't go outside what it's already ordered, and that's really important. And Vavilov really talks about making sure that the tribunal really is doing what it's statutorily required to do. It can't go back on its own orders. So determining whether something meets the normative standard is not the definition of Jordan's principle. this is what the tribunal is required to do. So at paragraph 157, the tribunal actually articulates the nature of the dispute and the, again, argument that Canada raised yesterday. So the essence of the dispute between the parties under this definition is whether the tribunal's judgment imposing a 12 and 48-hour standard for the provision of services should be the touchstone for compensation. The fact that Canada is bound by the tribunal's order to observe a much higher standard is a mechanism to ensure the long-standing injustices experienced by First Nations children will cease. However, minor deviations from those high standards should not lead to compensation. It is simply not evidence of discrimination to fail to achieve standards that exceed those of other jurisdictions and experienced by other children. So here we have a recognition on the part of the tribunal, which is quite reasonable, that first, those timeframes, those 12 and 24-hour timeframes, were put in place on a principled basis. They are not a comparative thing that need to be looked at, or nor should they be, because First Nations children have unique needs and have a unique history that has been respected by the tribunal throughout this process. But the tribunal, being the practical body that it is, says, okay, if there's some minor deviations from those timeframes, we're not going to say that there has been harm that's compensable under our scheme. And that's really important. It does recognize the concern raised by Canada that not every delay will be compensable. And so quite properly, what the tribunal does at paragraph 171 is say, okay, let's develop a mechanism that ensures that the practical nature of what Canada is saying and what's reasonable when we actually put this thing into action is fair. And so what they do is they create a rebuttable presumption that if there is a deviation from the time frame, then Canada can come forward, because it, of course, controls the information. It has the information. It can come forward and say it was actually a half an hour deviation or a 1 day deviation from the time frame. It has the ability to come to the central administrator, who will be the one distributing the funds on behalf of the government, and actually demonstrate quite easily, I would say, whether or not the deviation is reasonable. And that provides an avenue to ensure that Canada's concern about what's fair and reasonable is considered. And the central administrator will have the power to determine ultimately whether or not the delay was reasonable and unreasonable. If the delay was unreasonable, compensation will flow. If it was reasonable in the circumstances, that person will not get compensation. So that really demonstrates overall that the tribunal was alive to Canada's concern and developed a creative solution to address it. So overall, we say that the definitions decision, when you read it connected to the other decisions, particularly the merits decision, the Jordan's principle decisions, as well as the compensation entitlement decision, clearly demonstrates an internally coherent and consistent framework that we say should really not be interfered with. The definitions are functional, as evidenced by the compensation framework, and are going to make the process of getting the compensation to the victims relatively straightforward. So on that basis, we say the definitions decision is reasonable and should not be interfered with. And just for your reference, I should have taken this to you before, but my sticky note is on the wrong page. The definitions themselves are found at tab 50 of our compendium on page 721. So that's in the compensation framework, and that's where the actual definitions have been set out by the parties. So that's page 721 at tab 50 of our compendium. So if there are no questions about the definitions decision, I would like to turn now to some of Canada's arguments that were raised yesterday regarding the overall reasonableness of the compensation entitlement decision.
I just have just one clarification. Normally in a judicial review, there's a decision, and that's the decision that that the parties are focusing on. So here, I just want to make sure that you're clear. So we are concerning the compensation decision, but you're saying everything in between is relevant to what was arrived at in the compensation decision. Is that?
Yes.
So there's a trail. So it's not your typical JR. In some judicial reviews, several decisions can be considered altogether as flowing from one set of facts. But in this case, some decisions, or a few of these decisions were not judicially reviewed. So the process is what you're focusing on. And your submissions are that the process illustrates that it was a logical approach from the merits decision leading up to the compensation decisions. Is that, am I summarizing things properly?
Yes, Your Honor, very much so. And one of the things I would add to what you have just said is that Vavilov says that in order to demonstrate that a decision is reasonable, it has to be grounded in the facts and the law. And so when you look at the merits decision, those are uncontested facts and those are uncontested legal determinations. And that's the same with every decision that follows the merits decision. The facts and the law that stand in those decisions are the facts and the law of this case. So they can't be interfered with now on judicial review, really through the back door, which is what, in some respects, Canada is attempting to do. So not only when you look at the decisions together in their totality, do you see the reasonableness and the internally coherent nature of what the tribunal is doing, but it's also relying on the facts and the law as it stands in 2019, because those decisions were not interfered with by way of judicial review. So it's really a dual purpose in some ways. It's not only the overall nature of the case, but those are standalone decisions upon which the tribunal is entitled to rely. Those are the facts of the case. They've not been interfered with, and those are the legal principles that are the law as of now. So it's, with respect, I would say it's really a double-barreled way of looking at it, the overall case and the facts and the law as they stand.
Thank you.
So turning now to some of Canada's arguments, and I would say, because of the time constraints, you have our factum, you know our position on many of the issues, but I'm going to highlight a couple of areas just to ensure that we're crystal clear about the Caring Society's views on what Canada has been saying. So yesterday we heard Canada state that one of the problems it has with the compensation decision and why it thinks the tribunal was offside in awarding compensation to First Nations children was due to the lack of evidence, or really the sufficiency of the evidence. Now, just a reminder, Canada states that it accepts that it has discriminated against First Nations children and that First Nations children were harmed. We also heard yesterday that Canada views this harm as provable, just not proven in this case. Canada also said that it wants to compensate First Nations children for this harm. So as I said yesterday, these are difficult positions to reconcile. Really, this has been part of the narrative of this case. Canada says it wants to do the right thing, but it's just not able. It has always been able to compensate First Nations children for the harm they've suffered in this case. It's just chosen not to do so. So on this point, Canada seems to be making three overarching arguments. One, that there was no direct evidence from the victims themselves. Two, that the tribunal was borrowing facts when it shouldn't have been. And three, that the parties, including the Caring Society, have been attempting to plug the gaps in the tribunal's reasoning in order to sort of somehow bolster or save the compensation decision. Now, we say none of these arguments lend any credence to the suggestion that the tribunal's decision was unreasonable, and I will happily take you to that. So on the first point, there was no direct evidence from the victim. That's true. Children did not testify in this case about the harm they suffered as a result of the discrimination under the child welfare program or under Jordan's principle. And when I say the program for child welfare, I'm really talking about Canada's discriminatory underfunding. It's the actions of Canada that led to the discrimination and not some middleman. That's not how this unfolded. But direct evidence is not required in order for a victim to receive compensation. And the court's decision in Walden makes this point crystal clear. And that is found at tab 5 of the Attorney General's compendium at paragraph 73. The other important consideration to make, and I didn't hear Mr. Frater address this directly, is the flexibility that the tribunal has in accepting and reviewing hearsay evidence. And that's at section 50, sub 3, sub C of the Canadian Human Rights Act. This ability to receive this kind of evidence is really in keeping with the access to justice and pursuit of justice nature that is the Human Rights Act. The tribunal has this unique and wide flexibility in the way that it approaches discrimination claims to ensure that people like children and those who otherwise may not be accommodated within the system can actually have their voices heard and amplified. And we say that that is so essential to ultimately determining whether or not this idea of direct evidence from the children was necessary. Not only is it unnecessary, but the Act actually provides really important latitude of sharing evidence on behalf of victims when to do so would otherwise not be in the best interest of the children. Now, there was evidence. I don't want you to be under the impression that somehow only general statements of harm were found in the record and that we say that that's enough. We say probably it would be enough given the nature of the harm, but it's not true to say that there was no evidence. And I'd like to actually spend a little time really taking you through some of that evidence so that you can hear what the tribunal heard about what children were suffering. So I'm going to be in my compendium now for a little bit. I have mine in yellow. I don't know if you have a printed copy, Your Honor, but I'm going to be sort of moving through it with you because I think it's important to actually hear the words of the witnesses who were speaking on behalf of children. And I want to start with Elder Joseph. His testimony is found at tab 24, which is in the first volume of the compendium. And you'll recall that Elder Joseph was a witness in this case. He is a residential school survivor, and he was a part of the apology made by the Prime Minister. And he has some very important words of wisdom, which the tribunal reflects upon throughout its decisions. And he says, we have the state now saying, yeah, we made a mistake. We can't make the same mistake twice. These are the same children and their parents and grandparents, and we can't afford to continue losing children into despair and oblivion, detachment or loneliness, brokenness, or whatever it is. What he's speaking about here is the continued removal of children from their families. We have the history of residential school. We have the history of the 60s scoop. And what Elder Joseph is telling all of us is that we cannot continue to make this mistake a third time. Now, Daryl Dubois, who is a child welfare professional, he also testified at the tribunal, and his words are found at tab 33, which is in the second volume of the compendium. And this shows actually the direct harm between the underfunding and what was actually happening to children, as we described yesterday. He says, you had to break up a family under Directive 20-1, which is one of the funding formulas at issue here, before you could provide the service. It's only when you took a child into care that you could start to rebuild the family. This is what I was talking about yesterday when I say that Canada completely misunderstands the nature of the discrimination and the nature of the harm that flows from it. You actually could not help the family rebuild or address the protection concerns until you removed the child. We know that that causes harm, and I'm going to come to further evidence on that particular piece. Now, Dr. Blackstock also testified at the hearing, and before she was the executive director of the First Nations Child and Family Caring Society, she was a child protection worker. And so she had real expertise and lived experiences about what it was to provide social work to First Nations children and their families. Her testimony is found at at tab 22. I'm sort of pulling you all over the place, and I apologize. But as you can tell, I made this compendium before I prepared my submissions, as we often do on weekends before hearings. And so Dr. Blackstock talks at length in her testimony, and we haven't put it all in, but she really provided a lot of grounding and foundational knowledge to the tribunal and to the parties about what was actually happening for children. And so at tab 22, she talks about this process of removal, right? And she says, I can tell you that no matter how sensitive and how caring you are during this process, and she's talking about the removal process, it is a life-changing and often very traumatic experience for children and young people. She goes over to say on page 145, that the child lives in a lot of uncertainty. This is following the removal. A lot of things change in that moment of removal. They may be placed in a foster home where they aren't able to go to the same school, where they can't see some of their friends, where they can't have their favorite meal for breakfast. Those might seem like small things, but when you're going through a traumatic incident with a child, the most important thing is to try and keep as many things familiar. Now, it's important to understand that what we're talking about, again, is this moment of removal. We talked about yesterday the compounded and often differing impacts of the removal, and that those may be compensable in other venues, but here we're focused on the removal. Now, Sheila Murphy, who was a witness from Canada, she also acknowledged this harm around removal, and her evidence is found at tab 23. She actually says directly, taking a child away from their family and from their community has impacts for sure. When we see the word impact, we are not talking about a positive impact, and everyone knows that. Canada knows that. So this is yet an indication that the government itself knew that removing children caused harm. Very importantly, Marie Wilson filed an affidavit in support of the compensation orders that were made. And her evidence is very important, because what's interesting is she contextualizes the removal within the context of other important and compounding harms that were associated with residential school and the 60s scoop. And her evidence, as I said, is at tab 27. She says, going to the hearings, I was braced to hear accounts of sexual abuse. I imagined we would hear that this was the worst thing that could happen to children in the school system, but that was not the case. Over and over again, we heard that the worst part was the rupture from family and home and everything and everyone familiar and cherished. This rupture was the worst and the most universal. Now, Connie Bagley, who was a witness on behalf of Canada, also spoke about the harm and her knowledge of it. So I want to take you to tab 35 at page 575 of the record. And here we're talking about, or she's talking about, closing cases in Jordan's principle when children die. That's how they deal with it. It's an administrative ticky box. So she says, Mr. Poulin, who was examining her, says, cases are closed because the child dies. And she says, yes, there is this case, and then, yeah, that's it. So this approach to caring for children under Jordan's principle, if the child dies, they're not entitled to the service. They simply close the case. And the Caring Society is very concerned about the approach on Jordan's principle when it comes to issues like that. The last place I'll take you very briefly is Dr. Curlew's supplementary affidavit that was filed with respect to the NAN motion. And he talks about, and this just for your context, Your Honor, the community of Wapakika had requested some mental health services for children who were in a suicide pact. And the government's response at the time was that the request had come at an awkward time in the financial cycle. And Dr. Curlew actually says at paragraph 5 that he believes that the deaths were preventable. So that's really important that we understand when it comes to Jordan's principle, that sometimes we're talking about the lives of children. That is what is at stake. Now, Jane Doe says, the case of Jane Doe says that once you find pain and suffering, you must award compensation. Canada again says there is harm here, that it's provable, it's just not proven. We say that Canada should accept the proof that we have, as the tribunal did. Having children testify is completely unnecessary in this case, and the risk of re-traumatizing them is not the risk that we should be taking. Children within our justice system are treated differently for a reason. Their best interests are at heart, and we put their interests above those of the government. If we know that it's provable, then Canada should accept that it has been proven here. I think the last thing I want to say on this point is, what is it that Canada thinks it would learn from the testimony of children that it doesn't already know? In our submission, you don't need a child to come in front of other adults to talk about their experience of removal or to talk about their experience of being denied or delayed a service because of their First Nations identity. We know that it causes harm. Canada says it knows that it causes harm. It's not going to learn anything new by having a child testify about those experiences. And the risk of traumatizing that child is prejudicial and, frankly, not keeping in with the best interest of the child. Now, I'm going to move to the borrowing facts. I'm not going to spend too much time in these last couple of points here, but Mr. Frater yesterday raised a concern that the tribunal was borrowing facts and relying on documents and reports to support its findings. That issue has already been addressed by the tribunal. At paragraph 305 of the merits decision, the tribunal reviews this argument that was raised by Canada that it can't really rely on the NPR or the Wande reports or other government documents that were filed in response to the merits claim. The tribunal dismisses that and says, we accept the findings of these reports in their totality. Canada did not judicially review that finding. And so we say all of those reports, as referenced by the tribunal, form part of the factual foundation of the case here. Now, with respect to plugging gaps, we say, as I mentioned yesterday, that the tribunal says quite properly in its decision, we reviewed the entire record in order to come to this decision. And so the parties are not trying to plug holes as conceptualized by Canada, but rather what we've done is assist this court to review the evidence that was in front of the tribunal, evidence that the tribunal is intimately aware of and knows about. But, for the reviewing court, it's important that you have the full context. So this is not an attempt to plug holes. It's simply to demonstrate what the tribunal already knows and what the tribunal already had in front of it. I'm going to turn now to some of the concepts raised yesterday by Mr. Frater with respect to causality and proportionality, which we would really say is the tort law argument, and then hopefully wrap up shortly. So Canada is attempting to import principles from tort law into the human rights framework and then argues that the tribunal unreasonably failed to apply them. This is a classic example of an attempt, we say, to entice this court to import its own analysis and take a de novo look at the tribunal's reasons. But it also reflects, once again, Canada's misunderstanding of the human rights framework. Human rights and torts are not the same thing. They are not interchangeable legal concepts because they are really getting at different things. Unlike tort damages, compensation for pain and suffering and willful and reckless discrimination is not a mathematical exercise. Indeed, human rights compensation is something unique and special to our human rights framework, adjudicated by a specialized tribunal and therefore is entitled to deference. Now, there are some cases, as pointed out by my friend yesterday, where causality is a consideration when the tribunal is making a compensation award. But these are generally employment cases or business loss cases, as the Chopra cases, and so they're not applicable here. Moreover, we could have sought other kinds of compensation under the Canadian Human Rights Act, which may have required that causality and proportionality consideration. Particularly, I refer Your Honor to Section 53 sub 2, sub C and sub D of the Act. So these heads of remedy or these heads of compensation are for lost wages, which obviously requires some kind of a calculation of what has actually been lost, as well as additional costs for other things like services or counseling or other accommodation, which again has a requirement that there be some determination of what the cost of those things are. But we did not seek those heads of compensation in this case. AFN sought pain and suffering, and the Caring Society sought willful and reckless. And neither of those heads of compensation require any issue on sort of a mathematical approach, if you will, as discussed. So I just wanted to make that clear that the cases cited by Canada on this point are generally not relevant to this consideration because they are about compensation in different contexts and under different sections of the Act. Again, the compensation in this case is to redress the infringement of dignity. You got less because of your identity, and it recognizes the associated harms with that infringement. So it's not about causation. The other thing on proportionality, I would just say, and I know I've said this before, but I think it's a very important point, is that the tribunal did not award compensation to all children. We certainly requested that it be for every removed child, but it's only for those who were removed from their home, family, and community. So the Ontario Court of Appeal in Doyle and the Federal Court of Appeal in Jane Doe are really important principal decisions to examine, which stand for the proposition that compensation in these areas are about the intrinsic value of the infringement and the humiliating and degrading nature of the discrimination. As I said earlier, the tribunal properly placed limits on the scope and nature of the compensation award, and so the issues of causality and proportionality are not relevant. Ultimately, the tribunal's decision on this point was reasonable. Now, on the issue of class actions and the point raised yesterday that it better protects the rights of victims, we say that this is illogical and frankly unreasonable. What Canada is proposing really makes little sense within our justice system and our collective commitment to access to justice. Canada's argument really leads to an absurd result. Individual victims in a systemic case would be required to file a separate claim. It's inefficient and costly, and it's certainly clearly not in the best interest of children who have been waiting for Canada to comply with the orders and resolve the discrimination. It's completely unreasonable in the context of our human rights framework, which gives the tribunal reasonable discretion to control its own process and ensure that they are adjudicated informally and expeditiously. And this principle is really reflected in the rules governing the tribunal's process, in particular, Rule 1. The only party who would benefit from this process, this divide and conquer approach, would be the perpetrator of the discrimination, the federal government. To say that a process that involves a class action protects a victim's rights is highly suspect and is likely disingenuous of Canada to argue that a class action is better for victims in this case on the basis that a class action gives them more control. First, Canada has never put the rights of the victims in this case at the forefront of any of its decisions. As we discussed yesterday, the parties have had to return to the tribunal time and time again to force the government to comply with the merits decision. If they had actually been putting the rights and the consideration of First Nations children at the forefront, we would have resolved this case long ago. Second, this paternalistic and colonial view that it knows what's best for First Nations children has echoes of the past injustices. And so at this point, we say Canada should not be trusted on this point. Now, I'm going to turn now to my third point about what was raised yesterday, particularly with respect to the ongoing nature of the discrimination. Canada asserts that it was unreasonable for the tribunal to conclude that discrimination within the Child and Family Services program is ongoing because it ignores the tribunal's merits decisions and ultimately decisions that flowed thereafter. In addition, it's an argument that ought to have been made during the development and ultimately the approval of the compensation framework. There was significant time that this could have been raised with the tribunal between 2019 and ultimately 2021 when the compensation framework was approved. Now, in the merits decision, the tribunal expressly recognized that the discrimination was ongoing. At paragraph 483, the tribunal says, while a discriminatory practice has occurred and is ongoing, the panel is left with outstanding questions about how best to remedy this discrimination. So we knew in 2016, even at that moment, that the tribunal considered the discrimination to be ongoing. And any logical person would look at something like that and say, well, obviously something has to change if it's going to stop. So it was always within Canada's control to stop and cease the discriminatory practice. And what the tribunal is doing here is signaling to Canada that it views it to be ongoing. Since 2016, the tribunal has consistently determined, including in multiple orders registered with this court, that the discrimination in the program is ongoing. For instance, in its September 2016 order, the tribunal clearly stated more progress still needs to be made in the immediate and long term to ensure the discrimination identified is remedied. And that's at paragraph 8 of the 2016 CHRT 16 decision. Now, more recently, in the February 2018 order, the tribunal made another significant statement that was not challenged on judicial review. First, it said at paragraph 15, it is incorrect for Canada to say it did everything that it could do and everything that it was asked to do in the immediate term, which has now become midterm. Paragraph 19, more importantly, says, while a discriminatory practice has occurred and is ongoing, the panel is left with outstanding questions about how best to remedy the discrimination. This is yet another clear indication that that the tribunal views that Canada's discrimination is ongoing. In the face of such clear language, Canada cannot credibly suggest that it was unaware of the ongoing nature of the discrimination. To date, Canada has not led any evidence to indicate that, in the words of the tribunal, the unnecessary removal of First Nations children from their homes, families, and communities as a result of the discrimination found in this case has ceased. In other words, it was always open to Canada to lead evidence, to seek guidance, or to bring a motion before the tribunal with evidence that demonstrates that First Nations children are no longer unnecessarily removed from their homes as a result of their discriminatory underfunding. That has not happened, and it remains open to Canada to do so. Now, with respect to the Jordan's principal competence, oh, yes.
Just on that note, I think, if I recall, in yesterday's submissions of the Mr. Frater, I think, I'm not sure if it was directly on this point, but I think he mentioned that it's, the removals process is under the provincial system with provincial considerations. So what's your position on that when in terms of the evidence, how easily obtainable would that evidence be to, as you suggest, bring evidence to say it's stopped?
So first of all, that has always been the case. It has always been the case that an ultimate removal decision is made by a social worker and their team pursuant to provincial and territorial legislation. And in fact, this was one of the arguments that was brought forward at the merits stage, that, we're not a service provider. We don't have control over the decisions made by others. That was Canada's argument, one of many that they made at the merits decision. So that's always been the case. What the evidence has shown, and is what Mr. Dubois said directly in his evidence, is that those workers were having to bring children into care in order to get them services. So that's what the evidence supports. And that's actually when I take you through the willful and reckless section, although I see my time is just marching on, you're going to see directly that Canada was tracking this exact issue. It knew that its underfunding was leading to an overrepresentation of children in care. And that's because the only way to provide services to these children and family was to bring them into care, because the evidence showed that the government would pay 100 cents on the dollar for bringing them into care. You could offer any kind of services to children once they were in foster care. You could get them dental services. You could get them proper, food. You could get them better access to education. You could get them mental health services, medical services, counseling, parenting, psychological assistance. You could do all kinds of things that ultimately mitigate harm within the context of the family if you brought that child into care. So there are ways for the government to lead evidence about how that funding is being used and whether or not there's a proper relationship now between the service that it provides under the funding to see whether or not it's having an impact to stop that discrimination. That information is within the knowledge of the government. It always has been, as I'm going to show you in the willful and reckless section, and it continues to be the case.
Thank you.
So turning very briefly with respect to the Jordan's principal compensation, Canada says that it was treated procedurally unfair with respect to Jordan's principal compensation because it had not been sought until the portion of the remedies phase began. And while that is generally true, it's very important to say that ultimately there's not a procedural unfairness to Canada on this point. First, the tribunal recognized at paragraph 103 that the remedies are informed, yes, by the complaint, yes, by the statement of particulars, but also the nature of the case and the way that it evolves. Now, while Mr. Frater yesterday said he's not trying to treat the statement of particulars as a criminal indictment, what this argument ultimately amounts to is just that. We didn't really know the scope of the harm done to children under Jordan's principle until we started to see the proper Jordan's principle definition in action. So following 2017 until now, we now know that hundreds of thousands of requests have been fulfilled under the Jordan's principle legal obligation of Canada. So it was really not possible to appreciate the widespread nature of the discrimination. And as Dr. Gideon says in her evidence that's found in our compendium, there really was an unmet need. So we would say that it was completely open to the tribunal based on its flexibility and its discretion around remedies to award compensation under Jordan's principle in 2019, given its staged remedial phase and the scope and widespread nature of the discrimination with respect to Jordan's principle. So in my closing issue, I want to turn now to the willful and reckless nature of the discrimination. We say that the evidence clearly demonstrates that Canada's conduct was willful and reckless, and what the tribunal says as devoid of caution. Now, a respondent may be intentionally or recklessly discriminatory in its conduct. This is a disjunctive requirement. Both need not be present for the tribunal to make this kind of an award. But the tribunal has to be guided by common sense when it's considering this type of special compensation and really satisfied that the respondent had some awareness of the adverse impacts of its discriminatory actions on the victims in the case. Special compensation is to be reserved for the worst cases of discriminatory conduct where the respondent's infringement on the victim's right was intentional or otherwise known. And this is what we say happened in this case. The examples of Canada's willful and reckless conduct in this case are clear, consistent, and plentiful. At almost every turn, the discriminatory impact of its conduct was made clear, and yet Canada failed to act. Evidence-based solutions were presented, and yet Canada failed to act. Its own analysis, which I'm going to take you to in some quick manner, demonstrated that it knew its role in the discrimination and it failed to do anything. And this is true under both the service it provided under the child welfare program and under Jordan's principle. So it is important to look at the evidence in this case. Canada funded and partnered with many teams in those initial research studies, identifying the funding disparities under the First Nations Child and Family Services Program. Now, I won't take you directly to these, but it's important to review the NPR, which is found at tab 2 of our compendium, and the Wande reports, which are found at tab 3, 4, and 5 of the compendium. These reports together not only identify the discriminatory underfunding, the harm that is being experienced by First Nations children as a result of removal, but also a solution to fix it. That was not implemented by Canada. And so to say it didn't know that there was something it can do is not true. Second, Canada was provided with strong and reliable evidence before and after the complaint was filed that showed that the First Nations Child and Family Services Program was causing detrimental impacts to children. The Auditor General in 2008 and 2011 prepared a report that supported and verified the findings of the NPR report as well as the Wande reports and talked about the inequitable funding for First Nations children under the program. So obviously the government knew. The House of Commons Standing Committee on Public Accounts also looked at the Auditor General reports and actually invited the then Deputy Minister to speak about what was going on. This report, the Standing House Committee reports demonstrate Canada's awareness and knowledge that it was doing an injustice to First Nations children and kept saying it would do better. That in and of itself is an acknowledgement that it knew what it was doing. I think one of the really interesting documents to look at is at tab 14 of our compendium, which is an implementation evaluation of the enhanced prevention model. And what it says in that document is that prevention has failed to keep pace with the prevention requirements in the legislation and actually makes recommendations on how to fix it. But those two were not implemented. Finally, Canada's own internal documents demonstrated the disparity in services available to First Nations children and the impact of that deprivation. Canada measured and tracked the inequality experienced by First Nations children and family, and some of that is as follows. So first of all, in 2005, and this is actually, I think, a really important document to look at for just a really high level understanding of what was going on and what they do. And that's found at tab 15 of the compendium. So this is a secret presentation from April 12, 2005 that actually underscores the current situation for First Nations children. They knew they were struggling, they knew they were overrepresented, and that the current funding that was being provided by the federal government was totally inadequate. So that's something that this isn't being told to the government. This is the government telling itself that we are not doing right by First Nations children and that we are discriminating against them. There's a 2006 fact sheet that was on INAC's website for a period of time, which actually acknowledges the impacts and the findings of the NPR reports and goes on to say that First Nations children are disproportionately represented in the child welfare system. Placement rates on reserve reflect a lack of available prevention services. They knew what they were doing. That's at tab 16 of the compendium. There was a Q&A session that was prepared by the government about, what's happening in the program and what are we doing about it? And that's at tab 17. In answer to one of the questions, the answer is circumstances are dire. Inadequate resources may force individual agencies to close down if their mandates are withdrawn or not extended by the provinces. Circumstances are dire. They knew what they were doing. One of the things I also want to take you to is to tab 20 of the compendium. And this is an important, and I know AFN will be spending more time on this in the coming day or two, and that's at tab 20 of our compendium. But this is a PowerPoint presentation prepared by then ADM, Monsieur Ducrot. And really what this PowerPoint presentation does is actually track the disparity, track the discrimination, and tell the government, here's how we could fix this, but they don't fix it. So this is an important thing to examine. It's called the way forward. It was an attempt to sort of set out for the government how to redress this discriminatory underfunding. But for reasons that remain unclear, at least to me, they never really take Wande. They don't take the NPR. They don't take their own commentary, their own knowledge, their own spreadsheets, and actually redress the core of the discrimination. They simply don't do it. And it's on this basis that the tribunal quite reasonably says that Canada was devoid of caution and that it was willful and reckless with respect to the lives of First Nations children. So the findings, and this is also another important point, it's not just the evidence, but in the merits decision itself, the tribunal makes findings that Canada knew, and Canada did not judicially review that. I just want to highlight a couple of paragraphs in the merits decision for your bench brief to just demonstrate that this is not a new issue that came up in the compensation decision. And I would just point your honor to paragraphs 150 to 185 of the merits decision, 186 to 215, and paragraphs 385, 386, and 458. Now, the tribunal found that Canada similarly knew about the discrimination experienced by First Nations children seeking access to public services. Canada's own documents again demonstrated the disparity in services available to First Nations kids and the impact of that deprivation. They also knew that First Nations children were suffering the effects of failing to implement Jordan's principle. And those findings, again, at the merits decision are 258, 262, 265 through 68, and 270 to 275. And again, I would just point you to 458 and 481. So the Caring Society submits that from the moment the federal government unanimously passed motion 296, which is the Jordan's principle motion, it knew that it was failing to implement Jordan's principle, and that failure to do so would cause harm. Now, with respect to the direct evidence on this point, there is quite a bit of this in the record, and we do review a lot of it in our factum, so I would urge you to take another look at that. But it is important that I just point you to a couple of things. First of all, they were tracking it. So at tab 29 of our compendium, we included in there an internal tracking tool used by Canada to track Jordan's principle cases. And here what you're seeing in this tab is a description of a child who had something called Batten disease. And this is a fatal disease that has a really significant degenerative impact on the child's body. This child needed a special hospital bed in order to be able to properly breathe. And as indicated in the tracking tool itself, it's not that Canada didn't know, it wrote it right there in its own spreadsheet. The child needed to be at a 30-degree angle. The request was made in October of 2008, and it was not fulfilled until September of 2007. Pardon me. The request was made in October of 2007, and the request was not fulfilled until September of 2008. I think everyone in this courtroom knows that a child waiting for a bed that's going to help them breathe for almost a year is unacceptable, discriminatory, and harmful. I'd turn you also to tab 30 and to tab 31 of our compendium, which again shows that Canada knew that children were suffering and really demonstrates that they ought to have acted sooner to implement the full meaning of Jordan's principle as it was conceptualized in 2007 and not fully written down for Canada to review until 2017. And as I said, part of the reason for that was Canada's failure to comply over and over again. By failing to implement these recommendations, by failing to implement Jordan's principle, Canada was making the informed choice to deny the true meaning of Jordan's principle, and the respondent knowingly and recklessly discriminated against these children. Now, special compensation is reserved for the worst cases, and the Caring Society submits that Canada's conduct here far surpasses that. I encourage the court to look at Hicks and Johnstone for the principles enunciated there, because what we know is the test is not whether or not there were previous court orders, as suggested by Mr. Frater yesterday, that a respondent is violating. The test is, did you know, did you care, and did you try to stop it? Here, the answer is no. Canada did not. And so the conclusion that it was devoid of caution and found to be recklessly discriminatory, we say, is reasonable. Now, I'm coming to the end of my time, so I want to make sure you understand what the Caring Society is asking for. We are saying that this judicial review application should be dismissed in its entirety. The totality of the reasons are reasonable. This tribunal has a very specialized expertise, more so acutely by this panel, who has been seized of this matter since 2012. And overall, the entirety of the record demonstrates the reasonableness of what has been done to protect the rights of First Nations children. Now, if some portion is found to be unreasonable by this court, we do not agree with Canada's submission that this should be sent back to a differently constituted tribunal. First, it would be a complete disservice to the victims in this case. This panel knows this case inside and out, and we should be able to rely on the expertise of that panel to follow the direction of the court if it so sees fit. Secondly, it would be a disservice to the parties to try to have to re-educate a newly constituted panel on what has happened in this case would in some respects be unfair to the tribunal and to the parties. And so we say that it should go back to this panel if you see fit to send it back. There has been no allegation of bias here, and there's been no indication in the record or anywhere that I'm aware of that the tribunal would not follow the direction of this court if there was an aspect that needed to be readdressed. So in closing, the Caring Society wants to say that the evidence is clear that these children were harmed by the discrimination and they're entitled to compensation. Mr. Frater's comment yesterday about spending 3 days with a family friend outside of the community has been a jarring example for the Caring Society to hear. Removals do not result in 3 quiet days. Removals are not a vacation for a child. They are the state interfering in the sanctity of the family. During the testimony at the hearing of the merits, Dr. Blackstock testified about the number of nights that children spent away from their families. She actually provided, as part of her evidence, a spreadsheet of the calculation done to show how many children were in care and how long they spent away from their families. And that, for your bench brief reference, Your Honor, is at tab 118 of the joint record. So on February 12th, 2014, Dr. Blackstock testified about this spreadsheet and talked about how her math came to 66 million nights of children away from their families and homes. So if you add up all the days in care of children unnecessarily removed because they could not get equitable access to services, we know that these children have spent more than 66 million nights away from their families. When children are removed, they don't go quietly to a friend's house. Sometimes the police have to come and escort a child out of the house. Sometimes social workers, as brave as they are and as sensitive as they try to be, remove babies from their mother's care right after being born. And sometimes kids are picked up from school without any warning or knowledge that they're not going home tonight. While social workers do their best, we know that there is harm from being removed from their families. And so we would ask, Your Honor, that you really review the record in its entirety, the purpose of the Canadian Human Rights Act, and what the tribunal has reasonably done here, which is to compensate Canada's victims of discrimination. Subject to any questions, those are my submissions.
Thank you, Ms. Clark. No, I did have some planned questions on the individual complainant and the evidence, but you've answered that. So thank you for, I don't have any additional questions at this point. So thanks for those submissions.
Thank you, Your Honor.
I think that probably gives us a perfect opportunity for a break before the AFN begins. So I'll propose that we reconvene at 5 minutes after the hour. So in Ottawa, for those of you here, 11:05. So we'll see you in a few minutes.
Perfect. Discord is now in recess.
Recording stopped.
see everyone back from break. Perfect, thank you. We are ready to proceed.
I am.
Perfect, thank you, Mr. Justice Pavel. I will now prompt your recording. This court is now.
Recording in progress.
This court is now resumed.
Thank you. I hope everybody was able to refresh and get ready for the next bit of the morning. So I'll turn it over to the Assembly of First Nations. I know there are two council present, so I'm not sure if which one of the council will be leading this morning's submission. So I'll turn it over to the AFN.
Good morning, Moni, Justice Fable, from Council. My name is David Gubble, and along with my co-counsel, Stuart Wutke, we are representing the Assembly of First Nations. AFN is one of the respondents in these applications brought by the Attorney General of Canada. My Anishinaabe name is Gijganam, which means day star, and Maingun Dodem. My Dodem is Wolf Clan. I want to acknowledge that I'm located in Williams Treaty Territory and home to the Chippewas of the Rama First Nation. I also want to acknowledge Elder Sackney, who provided us with a ceremony for the opening of these proceedings. I wish him good health and that his community recovers from its struggle with the pandemic. These complaints were filed 14 years ago and resulted in 72 hearing days for the merits decision and numerous other hearing days for several judicial reviews by Canada and compliance motions brought by the complainants to get Canada to abide. Since 2008, Canada has engaged in a campaign of obstruction, delay, deflection, and non-compliance in the legal proceedings, alongside ongoing and knowing discriminatory conduct in its operations and utterly inconsistent political messaging to the Canadian and the First Nations public. Canada's callous response to these proceedings before the Canadian Human Rights Tribunal echoes the factual finding that the tribunal made about its conduct for the previous 26 years. And I quote, "Canada's conduct was devoid of caution, with little to no regard to the consequences of its behavior toward First Nations children and families. Canada focused on financial considerations rather than on the best interests of First Nations children and respecting their human rights." That summary, escaping liability for financial compensation, while continuing to knowingly violate the human rights of First Nations children and families, describes the impetus for these judicial review applications. It also represents the only explanation for forcing the tribunal to keep reconvening in order to tell Canada that all First Nations children on and off reserve were covered by the tribunal's 2016 order and Parliament's unanimous 2007 resolution about Jordan's Principle. How else to explain judicial review applications? Challenging decisions that were made several years before and repeatedly by the Canadian Human Rights Tribunal. How else to explain the recurring non-compliance orders against the Government of Canada? We have also to remember that all of this comes at a time when First Nations people, residential school survivors, Canadians, and people all over the world are being reminded about the horrors of Indian residential school. It is frankly heartless for Canada to be challenging the tribunal's decisions particularly the compensation decision, on the basis that there was insufficient evidence to establish harms resulting from the removal of First Nations children from their families, homes, and communities. How can they question that removing children from families causes harm? Especially given the fact that the removal of children from parents, homes, and communities during the Indian residential school era caused undeniable harm, and that the rate of removals as a result of Canada's child welfare policies is even higher. In the merits decision, the AFN focused on the Indian residential school issue and the similarities it bears to the federal child welfare policy. The First Nations Child and Family Caring Program, which I will refer to as the CFS program. We called 3 witnesses: historian Dr. John Malloy, to provide historical context for Indian residential schools. We called Dr. Amy Bombay with a PhD in neuroscience to give testimony on the intergenerational impacts of Indian residential schools. And Elder Robert Joseph to speak about his personal experiences in Indian residential school. Likewise, in this judicial review, a major focus for AFN is going to be on the connection to Indian residential schools, intergenerational trauma, and the issue of harm. Given that the Caring Society is focused on harm to the children, we will emphasize harm to caregivers, parents, and grandparents. And I want us to all think about that, because we are all parents, and certainly for me, aspiring grandparents. And so it's really important to be able to empathize and think about how we would feel about losing a child, or having a child removed from our care. Before going much further, I want to provide you with a roadmap of what we will be saying in our submissions. One, we're going to start out with submissions on the standard of review and the principles that ought to be applied by this court in this judicial review. I should point out that we are mindful of the need to avoid duplication amongst the other parties, so we'll be brief on this part. Next, we will review the history of these proceedings, reviewing the decisions in some detail, especially the merits decision, because as Vavilov directs, an important starting point for judicial review are the reasons of the tribunal. Thirdly, we'll provide the court with some focus submissions, again, mindful of duplication. So we've done some coordination with Council for the Caring Society, as I've indicated. I'm going to address 2 issues: compensation for harms to caregivers, parents and grandparents, as well as the willful and reckless compensation issue. Mr. Watke will address the remaining issues in his submissions, including compensation for harms related to Jordan's principle and responding to Canada's legal submissions, including the systemic versus individual discrimination issue and the class action argument, as well as perhaps other issues subject to time limitations, of course. So I want to start with the standard of review and related principles to be applied by this court. In both applications, Canada challenges the remedial jurisdiction of the tribunal to compensate and make whole victims of discrimination. In assessing Canada's claims, this court must take account of jurisprudence that establishes the following principles. Number 1, the Canadian Human Rights Act is a quasi-constitutional act and gives rise to rights of vital importance. These rights must be given full recognition and effect through a broad, liberal interpretation that will best ensure the objects of the act are achieved. Number 2, the same is true of the remedial authority of the tribunal, which must craft remedies to promote the rights being protected by vindicating the rights and freedoms of victims of discrimination. Number 3, moreover, this principle, like many others, has been afforded a broad, this tribunal, like many others, has been afforded a broad, discretionary remedial authority, and the court should hesitate to substitute its own views for the conclusions of the specialized expert body to which Parliament has delegated the task. Tribunals like this one are owed a particularly high degree of deference in their exercise of a broad statutory discretion to fashion an appropriate remedy. And that comes from the Canada Post case of the Supreme Court of Canada, adopting the dissenting reasons of Justice Evans in the Court of Appeal, paragraph 301. Number 4, this approach is indeed mandated by reasonableness review on which all parties here agree. Canada then ignores Vaviloff in asking this court to reinterpret the remedial language of the act afresh to match the position that Canada fully and unsuccessfully urged on the tribunal. The proper approach for the court is to ask itself whether Canada has met the high burden of showing that the rationale and the outcome of the decisions below were unreasonable. That's what Vaviloff asks. In our submission, it has not. Principle number 5, the court's restrained and deferential role on judicial review is to determine whether the tribunal acted irrationally or illogically in its chain of analysis. Given the specific context of human rights law and practice, and the facts and circumstances of this case, in which it was immersed for 9 years and has firsthand knowledge. Number 6, in particular, this court should resist Canada's barely veiled request to reweigh and reassess the evidence. Absent exceptional circumstances, the court should leave the tribunal's factual findings, which are virtually complete in this case, undisturbed. Number 7, with respect to statutory interpretation, the court is to pay, quotes, respectful attention and should defer to any decision based on an internally coherent and rational chain of analysis. And that's from Vaviloff at paragraphs 84 to 85. That is an accurate description of the reasons in this case, which I will take the court to later. Principle number 8, in reviewing for reasonableness, the reasons are not assessed against a standard of perfection. This is not a treasure hunt for error, and the reasons need not include everything a court would have preferred. Most importantly, according to Vaviloff at paragraphs 91 and 92, administrative justice will not always look like judicial justice. Principle number 9, the court should therefore consider the time span and duration of this complaint. 72 hearing days for the merits decision and countless other days in remedies hearings and compliance motions. More than 100,000 pages of documents that were put before the tribunal, the extensive written and oral argument, and the careful, logical, extensive reasons that the tribunal delivered in some 35 decisions, totaling in excess of 1,000 pages. After giving Canada a full opportunity to address every legal issue. Principle number 10. The tribunal's manner of proceeding was fully consistent with administrative law principles that recognize that it is not a court, and like other human rights tribunals that have heard such factually complex cases, the tribunal was not limited by court-like processes in focusing on how to effectively vindicate important statutory human rights. Principle 11. In assessing reasonableness, the analytical dichotomy between systemic and individual intentional discrimination that Canada asserted below and in this court was erased by the Supreme Court of Canada over 2 decades ago. Every year, there are hundreds of cases across Canada in which human rights tribunals award compensation to individual claimants after findings of discrimination against the victims. Number 12, the tribunal's remedial decisions should, in addition, be evaluated and upheld in light of its consistency with Canada's international obligations. Finally, the court should also place these judicial review applications in the context of Canada's relentless, ongoing, and long-standing refusal to accept the tribunal's jurisdiction, even before it had convened, or the obvious connection between Canada's role in First Nations child welfare and the requirements of the Act, culminating in the tribunal's strong, unchallenged finding of willful, discriminatory behavior toward one of Canada's most vulnerable groups over which Canada asserts jurisdiction, First Nations children and families. I want to move then to the history of these proceedings. Other counsel have outlined the sequence of decisions in this case, and we want to point out additional aspects of this history. There are common threads that are woven through this long procedural history, and they include the following. One of the common threads is the hoops that Canada has put First Nations children and families through to obtain justice. The sheer volume of evidence in this case, the length of time it's taken to get to this point, and the case is still not complete. The length of decisions, and of course, the tremendous expenditure of resources. Thankfully, the Canadian Human Rights Commission early on agreed to carry the case and has carried much of the load on behalf of First Nations children and families. But even with that, the costs have been great for the complainants and interested parties. Another common thread is that Canada has had the opportunity to address every issue that is now put before you. Therefore, its denial of fairness submissions are the most unreasonable portion of what it puts before this court. What it describes as an open-ended series of proceedings are in fact the tribunal's responsible management of the proceedings, as in other complex human rights cases, such as the McKinnon case, another Indigenous case referred to at paragraph 158 of our factum. What the tribunal has done to manage this case is what at times is required to complete its statutory case management and adjudicative functions, particularly in the face of a recalcitrant respondent like Canada. Another common thread is Canada's approach signals an unwillingness to accept that the effect of its child welfare policies to remove First Nation children from their families, homes, and communities is no different than the removal of children during the Indian residential school period. The tribunal has highlighted that Canada's policies perpetuate the historical disadvantages caused by colonialism, particularly Indian residential schools, and has caused intergenerational trauma. The decisions show that Canada is a serial violator of the tribunal's orders, which is contrary to reconciliation in light of the tribunal's mandate. The undoing of centuries of colonialism may take time, and that is an important aspect of the tribunal's fulfillment of its mandate to reduce and dismantle discriminatory practices. At the same time, Canada accepted and is now taking contrary positions on most of the issues it now puts before this court. We will focus on rulings made, not challenged, but attacked now, and there are very many. This has a number of results, and you've heard these from the Caring Society. Canada is out of time, and even if it weren't, the court should exercise its discretion to deny the discretionary remedy of judicial review, where the objection here was not made below. Another common thread in is the tribunal's careful, methodical, logical, consultative approach in its reasons and its orders. This is in line with the Supreme Court's approval of this approach, for example, in Quebec City and City of Montreal, and this court's admonition in the Grover case that often it may be more desirable for the tribunal to provide guidelines in order to allow the parties to work out between themselves the details of the order. And innovation and flexibility on the part of the tribunal is required in fashioning effective remedies. And the Act is structured so as to encourage this flexibility. It's important to spend some time with the tribunal's reasons. They speak for themselves. They demonstrate their reasonableness, and they show that Canada made the same arguments before the tribunal that it puts forward here. And every one of them was carefully, indeed exhaustively addressed. But before we address the tribunal's main reasons, I want to run through the procedural history that occurred before the merits decision. We cover this in our factum in paragraphs 10 to 16. Canada has made every effort to derail the process. The AFN and Caring Society originally filed a complaint in 2007. Canada urged the Canadian Human Rights Commission to decline to deal with the complaint, arguing that it was outside the Commission's jurisdiction. On September 30th, 2008, the Commission rejected that submission and referred the complaint to the tribunal. On November 11, 2008, Canada sought judicial review of the Commission's referral decision. By order dated November 24, 2009, Prothonatory Aronovich of the Federal Court stayed Canada's judicial review application pending the tribunal hearing. Canada appealed this order, and Mr. Justice O'Reilly dismissed Canada's appeal on March 30th, 2010. In 2010, the Attorney General persuaded the tribunal to prevent a public airing of the tribunal's proceedings by the Aboriginal People's Television Network, APTN. The Chief Justice of this court reversed that decision. Then Chief Justice Lutfi reversed that decision on June 30th, 2011. The Attorney General challenged the jurisdiction of the tribunal to hear the complaint. And this is in paragraph 14 of our factum, and I have to make a correction to that. Our factum says that it was actually the jurisdictional challenge was granted on the basis of service. In fact, in 2011, the tribunal accepted the Attorney General's submission that a comparator was a requirement under the Canadian Human Rights Act, Section 5B. So that jurisdictional challenge was brought on two grounds. One, that Indian Affairs' child welfare policies were not a service, and also that there was no comparator. The tribunal said they couldn't decide the service issue and deferred that, but they granted the jurisdictional challenge and dismissed the complaint based on the lack of a comparator, saying that a comparator was a requirement under the Act, Section 5B, and therefore the tribunal didn't have jurisdiction to hear the complaint. That was judicially reviewed to the federal court, and on April 18, 2012, the federal court, then Justice McTavish, set aside that decision and remitted the matter to a different panel. Canada appealed to the Federal Court of Appeal on May 22, 2012, and its appeal was dismissed the following year. On July 12, 2012, the acting tribunal chairperson ordered a 3-person panel to rehear the complaint. The tribunal formally dismissed the Attorney General's motion to end the proceeding. Canada objected to the parties amending their complaint to include allegations of retaliation and filed a motion to block expert witnesses of the AFN and Caring Society from testifying. Canada also sought to postpone the hearing of the complaint. On February 25th, 2013, the hearing on the merits finally commenced before the tribunal. But then again, something else happened. Through access to information requests, the Caring Society was able to obtain relevant government documents that Canada did not provide to the parties in tribunal disclosure. The parties were forced to file a production motion, and the hearing on the merits was delayed, allowing for additional disclosure by Canada. On this matter, the tribunal held the respondent's conduct, Canada's conduct here, is far from irreproachable, as demonstrated by the evidence brought by the Caring Society as a result of Dr. Blackstock's access to information requests. The respondent knew of the existence of a number of these documents. Prejudicial to its case and highly relevant in the summer of 2012, and yet failed to disclose them. I'm going to move now to the main decision in this case, the merits decision, which was issued on January 26, 2016. It's 2016 CHRT2. It's a lengthy decision spanning 170 pages, and it is a complicated decision which sorts through the complex arrangements between Canada and First Nation child welfare service agencies in the context of the relationship with provinces which have jurisdiction over child welfare. I'm going to ask Karen Osachov to pull up that decision, because we're going to be spending a bit of time with it. Okay, and we've borrowed this from the Caring Society's brief of cases. So I'm going to ask Ms. Osachov to take us to the table of contents first, because I want to show us the structure of the, the structure of the case is important. It's highly organized, very logical. It's starts with, of course, the complaint background parties, and it talks about the hearing, disclosure, and admissibility of documents, and it goes to the analysis. The analysis is part 5, and there are a number of separate parts to it, including A, B, and I'll go into these a little bit in more detail. C, and then we go to the part 6, which is the complaint substantiated, and part 7 is the order. So starting with part A of its analysis, this is pages 8 to 36 of the decision, and it covers the issue of the department is providing a service. I mentioned that earlier, that this was one of the questions, one of the defenses of Canada. So it covers the issue of the department providing a service via the CFS program and related provincial territorial agreements, like the 1965 agreement in Ontario. In summary, Canada made the age-old argument that child welfare is a provincial responsibility, that it was simply providing funding, and that funding is not a service. The tribunal held that funding could be a service. Moreover, in this case, the tribunal did a detailed review of the FNCFS program manual, including Directive 20-1, as well as a host of other arrangements, and concluded that Canada was not just providing funding. In fact, there are a lot of strings attached to that funding, to the point that it was exercising a large measure of control. In this part of the analysis, it's worth noting what the tribunal says about Canada's constitutional responsibility, and those are highlighted on the monitor. Paragraph 85, tribunal says, similarly, and at this point, I should mention that throughout the course of these decisions, we see the name change of the Department of Indian Affairs from AANDC to INAC. I'm just going to call it the department. So you might change, because you might change the name, but you don't change the institution, in my opinion. So paragraph 84, similarly, the department should not be allowed to evade its responsibilities to First Nations children and families residing on reserve by delegating the implementation of child and family services to CFS agencies or the province's territory. The department should not be allowed to escape the scrutiny of the Canadian Human Rights Act because it does not directly deliver child and family services on reserve. Paragraph 85, as explained above, despite not actually delivering the service, the department exerts a significant amount of influence over the provision of those services. Ultimately, it is the department that has the power to remedy inadequacies with the provision of child and family services and improve the outcome for children and families residing on reserve, on First Nation reserves and in the Yukon. This is the assistance or benefit the department holds out and intends to provide to First Nations children and families. In its analysis of the service relationship between Canada and First Nations with regard to child welfare, the tribunal also affirms the fiduciary relationship and says it could give rise to a fiduciary obligation at paragraph 104. In view of the above and the evidence presented in this case, the relationship between the federal government and First Nations people for the provision of child and family services on reserve could give rise to a fiduciary obligation on the part of the Crown. Paragraph 105. The CFS program and other related provincial territorial agreements were undertaken and controlled by the Crown. This undertaking is explicitly intended to be in the best interests of First Nation beneficiaries, including that the best interests of the child and the safety and well-being of First Nations children are objectives of the program. The Crown has discretionary control over the CFS program through policy and other administrative directives. It also exercises discretionary control over the application of the other related provincial territorial agreements, as First Nations are not party to those negotiations. The CFS program and other related provincial territorial agreements also have a direct impact on a vulnerable category of people, First Nations children and families in need of child and family support services on reserve. It's important to note that these findings have not been challenged by Canada, and they have a bearing on the issue of harm, particularly the fiduciary relationship and the vulnerability findings. Moving to the next part. Part B is an analysis of whether First Nations are denied or adversely impacted by child welfare services provided by Indian Affairs. That's at pages 37 to 142. This is a lengthy analysis of a very complicated child welfare legislative policy and funding framework affecting First Nations children and families on reserves and in the Yukon. It's also an extremely detailed analysis of the history of the delivery of child welfare services by the Department of Indian Affairs from the onset in the 1970s and the 1980s, but mainly starting in 1991 when the Indian Affairs role became formalized with Directive 20-1, which is a cabinet decision authorizing spending. The review of the history from this early period until the hearing included a review of the many reports on child welfare undertaken to assess the problems in First Nations child welfare, including three categories of reports. The first was mentioned by a caring society, the National Policy Review, which is referred to as NPR, which was a collaborative research project undertaken by Indian Affairs and AFN in the year 2000. Secondly, the 3 one-day reports, which were a follow-up to the NPR report. And this was another collaborative research project by AFN, Indian Affairs, and CFS agencies in 2004 and 2005. And of course, we have the Auditor General reports from 2008 and 2011, and related Public Accounts Committee reports, which were also mentioned by the Caring Society. These reports are significant because they constitute important evidence the tribunal relies on for its findings of discrimination, and also for the harm that it found was caused to First Nations children, families, and communities by Canada's discriminatory child welfare policies. The tribunal also heard a great many witnesses from both sides, and as well reviewed thousands of pages of documents to assess the impact of Canada's policies. A summary of the tribunal's findings on this issue are detailed in paragraphs 383 to 394. At 383, which is up, the tribunal says, the CFS program, corresponding funding formulas, and other related provincial territorial agreements intend to provide funding to ensure the safety and well-being of First Nations children on reserve by supporting culturally appropriate child and family services that are meant to be in accordance with provincial territorial legislation and standards and be provided in a reasonably comparable manner to those provided off reserve in similar circumstances. However, the evidence above indicates that the department is far from meeting these intended goals, and in fact, that First Nations are adversely impacted, and in some cases denied adequate child welfare services excuse me, by the application of the CFS program and other funding methods. In the remaining paragraphs, the tribunal goes on to list how Canada's child welfare policies result in adverse differentiation or in the denial of services. The most significant of these is the provision of full funding for apprehensions and underfunding of prevention or least disruptive services. This, of course, results in the removal of First Nations children from their homes and communities at greater rates than the height of the Indian residential school era. This is accomplished through the application of funding mechanisms and formulas that bear no relationship to actual needs, much like the preoccupation with per capita formulas during the Indian residential school era, rather than the best interests of the child and families and communities. At paragraph 393, which is also up, the tribunal finds that in the highlighted section portion, in fact, the evidence demonstrate demonstrates adverse effects for many First Nations children and families living on reserve and in the Yukon, including a denial of adequate child and family services by the application of the CFS program, funding formulas, and other related provincial territorial agreements. These findings are consistent with those of the NPR one-day reports, Auditor General of Canada reports, and Standing Committee on Public Accounts reports. Again, the panel accepts the findings in those reports and has relied on them to make its own findings. Those findings are also corroborated by other testimonial and documentary evidence outlined above, including the internal documents emanating from the department, some of which were read to you by Caring Society. These findings have not been challenged by Canada. Part C runs from pages 142 to 160 of the decision and is entitled Race and/or National and Ethnic Origin is a Factor in the Adverse Impacts or Denials. It has two main subheadings: substantive equality and impact of residential schools. With regard to substantive equality, the tribunal makes the point at paragraphs 399 and 394 that substantive equality is not necessarily about treating everyone the same, and in some cases requires purposive steps to ensure that disadvantaged groups benefit equally from services offered to the general public. And at paragraph 4402, the tribunal says, in determining whether there has been discrimination in a substantive sense, the analysis must also be undertaken in a purposive manner, taking into account the full social, political, and legal context of the claim. For Aboriginal peoples in Canada, this context includes the legacy of stereotyping and prejudice through colonialism, displacement, and residential schools. At paragraph 404, the tribunal concludes, the evidence in this case, excuse me, the evidence in this case not only indicates various adverse effects on First Nations children and families by the application of the department's CFS program, corresponding funding formulas, and other related provincial territorial agreements, but also that these adverse effects perpetuate historical disadvantages suffered by Aboriginal peoples, mainly as a result of the residential school system. With regard to the impact of residential schools, the tribunal reviewed the evidence of the witnesses I mentioned that we led during the hearing, namely historical expert John Malloy, Elder Robert Joseph, and Dr. Amy Bombay, an expert in intergenerational impacts of residential school. At paragraph 408, the tribunal recited the impact of residential schools from the testimony of Dr. Malloy, and it's highlighted. Overall, a large number of Aboriginal children under the supervision of the residential school system died while in care. Many of those who managed to survive the ordeal are psychologically scarred as a result. In addition to the impacts on individuals, Dr. Malloy also explained how the residential schools affected First Nations communities as a whole. In losing future generations to the residential schools, the culture, language, and the very survival of many First Nation communities was put in jeopardy. In the next two paragraphs, the tribunal recounted the evidence of Elder Robert Joseph and his quotes, very moving and detailed account of his personal experience in the Indian residential school system. And I won't repeat his testimony, but I urge you to read it. It's in our compendium and in the electronic record. At paragraph 410, the tribunal notes, and I think about Robert Joseph, he's very, very explicit in his testimony. It was moving, very moving. At paragraph 410, the tribunal notes that the residential residence gave him a deep sense of loneliness, and he turned to alcohol to cope with his despair. At paragraph 411, the tribunal reviews the 2008 statement of apology delivered by Prime Minister Harper, then Prime Minister Harper. And I want to read from some parts of his statement because it's important to this case. The statement starts, the treatment of children in Indian residential schools is a sad chapter in our history. For more than a century, Indian residential schools separated over 150,000 Aboriginal children from their families and communities. Two primary objectives of the residential school system were to remove and isolate children from the influence of their homes, families, traditions, and cultures, to assimilate them into the dominant culture. These objectives were based on the assumption that Aboriginal cultures and spiritual beliefs were inferior and unequal. Indeed, some sought, as it was infamously said, to kill the Indian in the child. Today, we recognize this policy was wrong, has caused great harm, and has no place in our country. The government now recognizes the consequences of the Indian residential school policy were profoundly negative, and that this policy has had a long-lasting and damaging impact on Aboriginal culture, heritage, and language. The legacy of Indian residential schools has contributed to social problems that continue to exist in many communities today. To the approximately 80,000 living former students and all family members and communities, the Government of Canada now recognizes that it was wrong to forcibly remove children from their homes, and we apologize for having done this. We now recognize that it was wrong to separate children from rich and vibrant cultures and traditions that had created a void in many lives and communities. And we apologize for having done this. We now recognize that in separating children from their families, we undermine the ability of many to adequately parent their own children, and sowed the seeds for generations to follow. And we apologize for having done this. One would have thought, if Canada really meant this apology, that it would not be contesting the harms to children and parents and grandparents by the continued removal as a result of its child welfare policies. At paragraph 413, based on the evidence of Dr. Malloy, the tribunal noted the transformation of the Indian residential school system from a, quote, school system from the 1880s until the 1960s, when it became a marked component of the child welfare system. In about 1969, the church's involvement in the residential school system ceased, and the federal government took over sole management of the institutions. At around the same time, new regulations came into effect outlining who could attend residential schools, placing an emphasis on orphans and neglected children. The primary role of many residential schools changed from a focus on education to a focus on child welfare. Despite this, many children were not sent home because their parents were assessed as not being able to assume the responsibility for the care of their children. At paragraphs 415 to 427, the tribunal addresses the intergenerational trauma of residential schools based on the expert report and testimony of Dr. Amy Bombay. And these are up and highlighted on the screen. Paragraph 415, Dr. Amy Bombay spoke about the intergenerational transmission of trauma among the offspring of residential school survivors. The panel finds Dr. Bombay's evidence reliable and helpful in understanding the impacts of the individual and collective trauma experienced by Aboriginal peoples, and finds her evidence highly relevant to the case at hand. Paragraph 417. According to Dr. Bombay, these collective traumas have had a cumulative effect over time, namely on individual and community health. In her words, these collective effects are greater than the sum of the individual effects. Similar effects have been shown in other populations and in other groups who have undergone similar collective traumas, such as Holocaust survivors, Japanese Americans subjected to internment during the Second World War, and the survivors of Turkish genocide of Armenians. To measure and describe the fact that some groups have undergone this chronic exposure to collective traumas, Dr. Maria Yellowhorse Braveheart of the University of New Mexico coined the term historical trauma, which is defined as the cumulative emotional and psychological wounding over the lifespan across generations, emanating from massive group trauma. At paragraphs 418, 419, and 420, reciting Dr. Bombay's evidence, the tribunal noted the impacts of Indian residential school to the physical and mental health and social outcomes, particularly with regard to parenting skills. And also that generationally, these impacts could descend from Indian residential school survivor to their children and then to their grandchildren. At paragraph 422, the tribunal indicated that Dr. Bombay's evidence helps inform the child and family service needs of Aboriginal peoples. Generally, it reinforces the higher level of need of those services, for those services on reserves. By focusing on bringing children into care, the CFS program, corresponding funding formulas, and other related provincial territorial agreements perpetuate the damage done by residential schools, rather than attempting to address past harms. The history of residential schools and the intergenerational trauma it has caused is another reason, on top of some of the other underlying risk factors affecting Aboriginal children and families, such as poverty and poor infrastructure, that exemplify the additional need of First Nations people to receive adequate child and family services, including least disruptive measures, and especially services that are culturally appropriate. The tribunal then addresses Canada's international commitments to children and Indigenous peoples in paragraphs 428 to 455. Of course, these are important, but I will leave it to Amnesty International to review these. At paragraphs 456 to 467, the tribunal declares the complaint substantiated. Paragraph 458 lists the main adverse impacts. The department's design, management, this is 458, design, management, and control of the CFS program, along with its corresponding funding formulas and other related provincial territorial agreements, have resulted in denials of services and created various adverse impacts for many First Nations children and families living on reserves. It non-exclusively lists the main adverse impacts resulting from the department's preoccupation with funding formulas rather than the actual needs and best interests of First Nations children and families. The most significant impact is the removal of children, First Nations children, by underfunding prevention services and fully funding apprehensions. The main adverse impacts found by the panel are listed, and I won't go through them all, but they're important to understand. At paragraph 459, the tribunal finds that the CFS program, corresponding funding formulas, and other related agreements cause these adverse impacts. And these adverse impacts perpetuate the historical disadvantage and trauma suffered by Aboriginal people, in particular as a result of the residential school system. At paragraph 461, which is up, the tribunal finds that despite being aware of these adverse impacts for many years, Canada has not significantly modified the program since its inception in 1990, nor have schedules to the 1965 Ontario Agreement been updated since 1998. At paragraph 467, with respect to the issue of harms, the tribunal, quotes, acknowledges the suffering of those First Nations children and families who are or have been denied an equitable opportunity to remain together or reunited in a timely manner. This finding of suffering was not challenged by Canada. Certainly not then. Part 7 of the merits decision, starting at paragraph 468 through to the end of the decision, deals with the order. At paragraph 481, the tribunal lays out its main order, which is that the department is to cease its discriminatory practices and reform the CFS program and 1965 agreement to reflect the findings in this decision. And it is also ordered to cease applying the narrow definition of Jordan's principle. Paragraphs 485 to 90 deal with compensation. In paragraph 485, the tribunal sets out its authority to award compensation for pain and suffering under section 53(2), paragraph E, and for willful and reckless under section 53, sub 3. In the succeeding paragraphs, it recites the parties' respective positions on compensation. It notes Canada's position: insufficient evidence of harm to children, particularly unproven premise that all these children were removed from their homes because of the department's funding practices. Similar to the arguments that it has made here. At paragraph 483, the tribunal notes that the discriminatory practice has occurred and is ongoing. But says it requires clarification from the parties on the remedies requested, including immediate and long-term reform, as well as compensation. Subsequently, the tribunal advised the parties that it would approach remedies in 3 steps. First, it would deal with immediate reforms to the CFS program, the 1965 Ontario Agreement, and Jordan's Principle. Second, it would deal with long-term reforms. And third, it would deal with compensation. Excuse me. 3 months later, on April 26, 2016, we have the tribunal's first compliance order. And that's decision 2016 CHRT 10. Do we have that one up?
Yep.
Okay. At paragraphs 10 to 19, the tribunal sets out remedial principles, including at paragraph 14, that it must ensure its remedial orders are effective in promoting the rights protected by the Act and meaningful in vindicating any loss suffered by the victim of discrimination. At paragraphs 21, 22, 23, and 24 of this decision, the tribunal chastised the department for not undertaking immediate changes. At paragraph 21, it questions why it has still not addressed immediate reform 3 months after the merits decision. It orders the department to take immediate measures to address the reforms it ordered in the merits decision. That's at paragraph 23. It says the best course is to require the department to provide ongoing reporting to the tribunal. That's paragraph 22. Starting with a comprehensive report within 4 weeks. Then it says the parties will meet with a panel to discuss the report, ask questions, make submissions, followed by further ruling if necessary. In other words, the tribunal ordered a continuing process of supervision. At paragraph 32 of this decision, the tribunal reiterated that its order in the merits decision was to implement the full meaning of Jordan's principle. Departmental officials, federal officials had said, well, they were in the process of talking to deal with the implementation of Jordan's principle. So the tribunal says that its order in the merits decision was to implement the full meaning of Jordan's principle, not to immediately start discussions to review the definition. The House of Commons resolution provided, according to the tribunal, a workable definition. Canada can review it in the long term, but shall implement the current definition now. At paragraph 33, the tribunal ordered the department to immediately consider Jordan's principle as including all jurisdictional disputes, not just in intergovernmental disputes, but disputes between departments as well, and involving all First Nations children. There was no challenge to this decision. 5 months later, we have the decision of September 14, 2016, another compliance decision. That's 2016 CHRT 16. Following INAC's or the department's comprehensive report, they'd ordered a comprehensive report, now they're reviewing it. This decision is an update on progress towards implementing the merits decision. At paragraphs 28 to 36, the panel notes some progress by the department, but expresses frustration with what it calls the department's old mindset, as reflected in the following: by the department's decision to unilaterally defer some immediate reforms to mid or long term. 2, by the department using the need to consult with First Nations and CFS agencies as an excuse to delay implementing reforms. We've all heard these excuses before. Excuse me. And thirdly, by the department's preoccupation with funding formulas and amounts rather than meeting actual needs according to the circumstances of First Nations children, families, and communities. The tribunal reiterates that its immediate relief orders are for immediate relief at paragraph 36. As well, in the succeeding paragraphs, it goes on to make even more specific orders on a range of items previously more generally addressed in the merits decision. At paragraph 116 to 119, the tribunal says explicitly for the second time that it has ordered Jordan's principle to apply to all First Nations children, not just those living on reserve. Canada's position in attempting to narrowly interpret two paragraphs of the tribunal's 2016 decision is rejected. At paragraph 160 of the decision, the department is ordered to provide further compliance reporting regarding the specific orders issued by the tribunal. This decision was not challenged by the Attorney General. We have on May 26, 2017, a further compliance ruling. This is reported at 2017 CHRT 14. In March of 2017, the complainants and interested parties brought a series of motions regarding Canada's non-compliance with immediate relief measures. We're still in the immediate relief measures stage, which were heard over 3 days in March of 2017. This decision relates to the Jordan's principle aspects of those motions. At paragraph 32, the tribunal describes its approach to remedies, citing the Grover case as support for its approach, but it's often more desirable for the tribunal to provide guidelines in order to allow the parties to work out between themselves the details of the order, rather than to have an unworkable order forced upon them by the tribunal. At paragraph 41, the tribunal finds that Canada, quotes, still has not implemented Jordan's principles' full meaning and scope, applying a narrow definition of Jordan's principle that's not in compliance with the panel's previous orders. At paragraph 69, the tribunal rejects the department's emphasis on, quotes, normative standards of care, because it does not answer the findings in the merits decision with respect to substantive equality and the need for culturally appropriate services, especially in light of the historical disadvantages of First Nations children and families as a result of residential school. I note this is something Mr. Frater mentioned in his submissions, yet it doesn't appear that Canada challenged this decision. February 1, 2018 is a major decision which flows out of the series of motions that I mentioned were brought in March 2017. This ruling covers issues other than Jordan's principle. And there are a number of noteworthy passages in this decision. At paragraph 41, the tribunal reminds Canada that the merits decision was not a recommendation. It is legally binding. At paragraph 62, and in response to the department's position that delay is needed to consult, the tribunal stresses how important it is to address the issue of mass removal of children today. The AFN requested two major things in the March 2017 motions. First of all, after over a year since the merits decision, the department had still not stopped incentivizing the removal of First Nations children from their families and communities. It was still fully funding apprehensions and not fully funding prevention services. Therefore, AFN requested and the tribunal ordered that funding for CFS agencies be covered based on actual needs. The Caring Society and the interested parties agreed and additionally asked for a range of other items to be covered on the basis of actual need. The tribunal made a range of orders to this effect. Secondly, to address concerns related to consultation, because that had been an ongoing excuse by the department for the failure to implement. The AFN asked for an order that Canada be required to enter into a consultation protocol, setting out the consultation obligations of the parties. An order was made that Canada enter into a consultation protocol in accordance with the Honour of the Crown. In the result, a consultation protocol was negotiated and given force pursuant to the order of the tribunal. Regarding the issue of harm to First Nations children and families, at paragraph 115, the tribunal says, the panel makes its immediate midterm orders in addressing a broken system that is harming children and removing them from their communities instead of allowing them to remain safely in their homes with the benefit of sufficient culturally appropriate prevention services. To support the finding of harm, the tribunal referred, among other things, to the affidavit of TRC Commissioner Marie Wilson. And you've heard this, but I'll repeat it because I think it's important. Her evidence is referred to at paragraph 122. She affirms that she personally bore witness to 1,500 statements made to the TRC. Many were from those who grew up as children in the foster care system as it currently exists. She also heard from hundreds of parents with children taken into care. Over and over again, she states the commissioners heard that the worst part of the residential schools was not the sexual abuse, but rather the rupture of the family and home. And everything and everyone familiar and cherished. This was the worst aspect and the most universal amongst the voices they heard. At paragraphs 376 to 379, the tribunal addresses Canada's arguments of unfairness in process. And I'll refer these, and I'll take you to these passages. I'll actually take you to these passages because Canada's arguments are almost exactly the same argument they're making now, as the Caring Society has indicated. At 376, the Attorney General in its submissions raises the point that since the decision in 2016, there have been efforts to expand the scope of the tribunal's remedy process to include matters that were not raised or dealt with at the original hearing. For example, the parties have devoted considerable time and resources to have an inquiry, and in this case, it was mental health funding, even when information about funding was provided. The Attorney General submits the parties' continued efforts to raise new issues and seek more information raises concerns about the fairness of the process, which is in danger of becoming open-ended and indeterminate, with more sessions being scheduled as more allegations are being raised. The parties are entitled to clarity and information on when to expect the process to end. Paragraph 378. The panel understands the Attorney General's position and has a number of comments. 379. Mental health formed part of the evidence at the hearing on the merits. It was also addressed in the decision, and therefore it's not a new issue. Very importantly, the next part, the tribunal says the respondent has been found to discriminate in order to cease the discriminatory practice in accordance with the panel's findings. It is for the respondent to clearly demonstrate it has complied and how it addressed the discriminatory practice. These reasons would appear to answer Canada's procedural fairness arguments, particularly the submission that the tribunal owed Canada a duty to give notice that the discrimination was ongoing. There was no challenge to this decision. So that's completed a review of the decisions, Justice Fable, that I intend to review. We would now be moving to the submissions. We can either break now or I can continue and finish. I think I can finish those submissions.
Thank you, Mr. Nagabo. I think in light of the time, I think we could probably use a lunch break. So we will, in that case, I think we'll reconvene at 1:30, just over an hour of time, and then we'll hear your further submissions as well as your colleague, Mr. Wetke. So we'll reconvene at 1:30.
Very good. Thank you. Thank you, Your Honor.
Perfect. The court is in recess until 1:30 for lunch break.
Recording stopped.